The Criminal Subcommittee of the Judiciary Committee will come to order. Clerk, call the roll, please.
Senator McDougal. Here. Senator Norman. Here. Senator Stanley. Here. Senator Morrissey. Senator McClellan. Here. Senator Servo.
Here.
Mr. Chair, you have a quorum.
Thank you, Mr. Clerk. Ladies and gentlemen, the way I intend to handle this docket, hopefully if people are here, is to handle Senate Bills 126 and 687 first. It's Mason Obenshain. Senator Mason's bill second, that's 198. Then go to the rough sprawl catalytic converter bills third. Then Senator Peterson, Boysko, then the two Evan bills, and then the Edwards bills last. That's how I hope to handle the docket today, everybody, and I hope to be out of here by 6 p.m. Having said that, first we call up Senate Bills 126 and 687. Senator Mason, it's my understanding that Senator Obenshain would like Senate Bill 126 rolled into Senate Bill 687. I'd entertain that motion. Is there a second? It's been moved and seconded that we roll in Senate Bill 126 into Senate Bill 687. All those in favor say aye. Anybody opposed? Nobody opposed. You get that, Mr. Clerk? You get that, Mr. Clerk?
My apologies, Mr.
Unanimous
Chair.
vote.
Yes, sir.
Roll. Okay, thank you. Having said that, Senator Mason, can you present Senate Bill 687? We've talked about it a little bit and already, but or at least some of us have.
Thank you, Mr. Chairman. There is a substitute too. And so while it's being handed out, this is a recommendation from the Virginia Criminal Justice Conference, and it really just tries to clean up some of the code sections speaking to what we called previously incapacitated adults, and now we're calling vulnerable adults. The sub essentially removes line 81, I believe, where we stated advanced age. As a friend of mine from my local region suggested some people may have taken umbrage.
That was me, Mr. Chairman.
Mr. Benjamin, anytime you take umbrage, I accept the amendment. So we removed advanced age as defined by older than 65. So that's out. Let
Mason, yes, also just clarify, in addition to removing it from the definition section, did you also remove it from the definition of vulnerable adult?
Let me find the.
Yes, Mr.
Looks
Chair.
to me like
I
you
believe we did. Yes, sir.
Yes, Mr. Chair. So the definition of vulnerable adult now means any person 18 years of age or older who is impaired by reason of mental illness, intellectual or developmental disability, physical illness or disability, or other causes, including age, to the extent the adult lacks sufficient understanding, et cetera, et cetera.
Got it.
So it's taking out advanced age and just uses age as a consideration.
Got it. So the bill is written basically makes it a crime to take advantage of a vulnerable person who's over the age of 18, and it sort of cleans that all up.
Yes, that's the bill, Mr. Chairman.
Okay, it's been approved by the Virginia Criminal Justice Commission.
Yes, sir, Mr. Chairman.
Okay, does anybody have any questions for the patron? No questions. Okay. We took advanced age out of the definition. Yeah. Okay. Senator Mason, do you have anybody speaking in favor of the bill?
Yes, Mr. Chairman, quickly.
Good evening, Mr. Chairman. Nathan Green, Commonwealth's Attorney for the City of Williamsburg, James City County. I actually get to wear two hats today. I'm speaking on behalf of Virginia Association of Commonwealth Attorneys, as well as VCJC. This, again, is a bill at the request of VCJC, cleaning up the incapacitated adult is used in different places. Vulnerable is a more accurate and better language, we believe. Again, this was the work from the study committee from VCJC, so both support.
Thank you, Mr. Green. Good to see you.
Good to see you. Thank you.
Attorney General's office.
Mr. Chairman, members of the subcommittee, Josh Humphries with the Attorney General's office. For the reasons previously stated, we support the bill. We previously had supported Senator Obenshain's bill, but we're happy to support Senator Mason's.
Got it. Is there anybody in support in the Zoom room?
For those attendees in the Zoom room who would like to speak in support of the bill, please raise your hand electronically now. Mr. Chair, there are no hands raised at this time.
Thank you. Is there anybody in opposition in the room or the Zoom room? It's been moved and reported, moved and seconded that we recommend reporting, and I assume, is this finance? Yeah, isn't it? Charles?
Yes, Mr. Chair. This will have to go to finance.
Okay. Recommend reporting to and re-referring to the Finance Committee. All those in favor say aye. Anybody opposed? Okay. Morrissey's not here yet. Okay, thank you, Senator Mason. Now,
Thank you, Mr. Chairman. Senate
Senate
Bill
Bill
198, and it either has an amendment or a substitute.
Okay.
Substitute. Got it.
Mr. Clerk, Senator Deeds was also aye on that motion.
This vote will be noted, sir.
So, Mr. Chairman, while he's handing it out, we've been working really hard to try to come up with a different disposition to folks that end up in court and are incompetent to stand trial to be there. We have a longer-term effort going to try to come up with a civil path. As you know, we have mental health dockets that could be, we could triple, quadruple the number of people that they see. This is an attempt to, this changes nothing. You still have the evaluation. The evaluation comes back, they determine they're not competent to stand trial. It's at that point, it gives us another option. So if the Commonwealth Attorney and the defense, we struck a line that was a part of the other effort. He was just inappropriately placed in here that spoke to a predetermined finding of guilt. That's out. This would be when the Commonwealth Attorney, the defense attorney agree that we can handle this in an outpatient manner. We'd null process charges and then try to handle through a mandatory outpatient treatment. We know we struggle with community-based treatment, but this is just an effort to give us another option to keep from sending people to our state-run mental hospitals for an average of 52 days for misdemeanor charges.
Senator Peterson, is part of the problem that once somebody is found to be incompetent, you can't dismiss a charge, do a motion null pos until their competency is restored? Is that partly what this is seeking to resolve?
I'm sorry, I can't understand you, sir. I apologize.
It's partly what this is trying to resolve is the fact that if somebody is found incompetent, you can't null pros dismiss the charges until their competency has been restored?
They have at this point, you have one option. This is designed to give the court multiple options with agreement from the Commonwealth Attorney and the defense.
Okay. Do you have witnesses in favor of the bill?
I do, yes, sir.
Can anybody supporting the bill please come up and testify?
Good evening, Mr. Chairman. At this time, I am actually coming up without a hat. Nate Green with the Commonwealth Attorney's Office from Williamsburg and James City County. And to be clear, I'm not speaking on behalf of the Virginia Association of Commonwealth Attorneys on this one. This is a bill that came out of a work group that I participated in over the summer and into the fall. The issue that was being addressed was the high volume of individuals who have committed low-end misdemeanor crimes, trespass, petty larceny, disorderly conduct, who are arrested, brought before the court, and their attorney asks for a competency evaluation. They then are evaluated, and they come back as not competent. Currently, under the law, it does say the court shall restore them to competency. I will say our judge allows us, the Commonwealth, to null pros the case if we so choose, but then we're doing nothing. This is another option, a highway to get them to treatment rather than forcing them to go through the competency restoration process. I will tell this committee that restoration to competency and treatment of certain mental health issues are not always the same. They are very different. And getting someone enabled to be competent to stand trial may do nothing towards their actual mental health problems. And so what we're doing is restoring them to competency on a petty larceny so that we can then bring them back to court several months later to then say, Judge, we would like to do a withhold finding, or we'd like to place them on probation and get them treatment. This is just a faster way to get them to treatment without gumming up the works either in the court system or in the hospitals, restoring individuals' competency.
I think we have a question. I also have a question for counsel.
Certainly.
Senator Norman.
Nate, as I'm looking down here on line 79 and 80, it just indicates that can enter, order, null pros, or dismiss for the criminal charge. There's a heck of a difference between a null pros and a dismiss on it. And do we really want to put that dismissal provision in there?
Again, this was a work group. Not one person got to control all the language of the work group. Null pros is what was advocated for by some. The language was, again, a collaborative effort. I will point out that this has to be done with the Commonwealth's concurrence. If even on a petty larceny, the Commonwealth decides, you know what, I want this person restored to competency, I want them to be, they can put a block on it and say, no, we're not going to do this off-ramp, we're going to go through the competency route. So there is some protections there as well.
Mr. Grant, I think what Senator Norman was saying is, would you be opposed to dismissal without prejudice?
Not at all.
Yep, that was my next thing. Thank
Not,
you,
not,
Mr. Chair.
not at all, but again,
Okay.
I also want to respect the work of the group.
Well, I wasn't in the work group, and I don't
So-
like that word in there.
Okay, is that a motion
I move to delete or dismissal on 79 and 80.
instead of saying
Or
dismissal without prejudice?
Yeah, whichever way you want.
I'd like dismiss without
All
prejudice
right,
better.
dismissed without prejudice.
Council understand the amendment?
Yes, Mr. Chair.
Okay, does anybody second the amendment? Okay, all those in favor of the amendment, say aye.
Aye.
Aye, anybody opposed? No, okay. I had a question for council. My only concern about this bill is whether or not there's some kind of a constitutional restriction or something on taking an action in somebody's case if they've been found to be incompetent. Are you aware of whether there's any kind of either of you guys, whether there's any kind of legal issue of doing something to somebody when they've been found to be incompetent? And I agree with the policy.
Mr. Chairman, may I suggest an answer there?
Sure.
I think there are absolutely due process rights to take criminal action against somebody who's not competent. However, if someone's not competent, you could still have them civilly committed. You don't have to be competent to be civilly committed, nor do you have to be competent to have a bond hearing. There are certain steps that can be taken without competency. Of course, a preliminary hearing or a plea or anything of that nature, they would have to be competent, but we're not trying to do any of those things.
That's correct, Mr. Chairman. I do have a question probably for Nate or Senator Mason.
Mr. Benjamin.
On line 78, the alternative 78 through 80, does the alternative of a null pros or a dismissal without prejudice, does that assume that there will be involuntary admission?
No. It allows for that review, and it also allows for, we are doing a lot of work on this mandatory outpatient treatment route as well. Again, this is the Commonwealth giving up its opportunity at the time to pursue the criminal case any further because we recognize that that services, that mental health rehabilitation is more important than getting a petty larceny conviction or finding. If it takes a while and it doesn't work, we may run out of time on a misdemeanor. But again, this is an option available to get a number of people off this off-ramp or off this highway of long-term competency restoration when what we really want to do, our end game is get them services, get them treatment. So this is just a way to get them to treatment, and it may involve null prosing the case, and we don't get to go forward on the petty larceny. But again, I think the greater good is addressing getting them treatment as opposed to getting them found guilty of a petty larceny.
Mr. Chairman, Mr. Chairman,
Uber Chairman Edwards.
I have a question. Have we deleted with that the court, without objection to counsel, finds by clear and convincing evidence the crime has occurred?
Yes.
That's all.
It's gone.
It's gone. Well, good.
Yes, sir.
Mr. Chairman,
Mr. Uber Chairman, you're looking at the original bill and
Yeah,
not the
well, I am.
substitute.
Yes, sir.
Okay.
question, Mr. Chairman.
Mr. Benjamin.
I don't think this is your bill, Senator Mason, but one question I have, in case it does touch on this, something that I'm seeing with greater frequency is the incidence of defendants who, because of dementia or Alzheimer's, are unrestorably incompetent. And I'm concerned that our present mechanism requires an effort to restore competency, which can be disastrous.
Mr. Chairman,
Mr. Green.
to answer the question, believe last section, if not the session before, we took at least a step in that direction to say if someone has been found to be unrestorably incompetent in the past, you can come forward and you don't have to go through the restoration process because you've already, that finding has already been made. So someone has been found unrestorably incompetent on a larceny. 6 months later, they commit a new offense. You don't have to go through the competency. You don't have to do it all over again. You can rely on that previous finding.
Thank you.
That's exactly, we fixed that last year because of that very issue.
Okay. I'm going to be a little unorthodox here and do it rough style. And I want to see if there's anybody opposed to the bill.
Thanks.
there anybody in the Zoom room opposed to the bill?
For those attendees in the Zoom room who would like to oppose the bill or speak in opposition to the bill, please raise your hand electronically now. Mr. Chair, we don't have any hands
Okay. Is
raised.
there anybody that would like to seize victory from the jaws of defeat? Okay, I'm not seeing anybody.
We recommend reporting the bill.
And re-referring it to finance?
Referring to finance.
Okay, there's been a motion and a second to recommend reporting and re-referring to finance. All those in favor, say aye. Okay, anybody opposed? All the proxies, aye, except Morrissey. Morrissey's not here. Okay, thank you, Senator
Thank you,
Mason.
Mr. Chairman, members of the committee.
Okay, Senators Ruff and Sproul, you guys are up. Senator Peterson's on deck, and Boysko's in the hole. Sproul and Ruff, Senate Bills 41 and 729 are bills that have to do with catalytic converter theft.
Yes.
And I've been getting emails from constituents about this for like the last 2 weeks. Apparently, somebody's taking them off Priuses in my neighborhood. It's a real problem, and there's two separate approaches here for the committee. Senator Sproul's approach is mainly a criminal approach. Senator Ruff's approach is partially criminal and then has some information, some regulations on parts resellers and stuff. And Senator Ruff, I believe you have a sub. Is that right?
Correct.
Okay, I'd entertain a motion on Senator Ruff's.
Substitute.
Okay, there's a motion. All those in favor say aye. Aye. Anybody opposed? Okay, Senator Ruff's substitute is in front of us. And Sproul, why don't you go first, and then Senator Ruff, why don't you explain how your bill's different, and then we'll go from there.
Thank you, Mr. Chairman. Catalytic converters is a growing problem across the Commonwealth of Virginia and many other states. Virginia State Code 18.2-23 currently reads a person shall conspire, confederate, combine with others in the Commonwealth to commit larceny, assist in abet, the performance of a theft over $1,000 is committed as a felony. Oftentimes, person will conspire to commit the theft of a catalytic converter. The problem that arises in the prosecution of these thefts established in the value of the catalytic converter. If the value cannot be proven to exceed $1,000, there is currently no code to detect and punish the person for the crime of conspiracy to commit a larceny under $1,000. The purpose of this bill, Mr. Chairman, Virginia Code 18.2-23 will certainly aid law enforcement officers with the investigation and prosecution of catalytic converters, theft when the value of the converter is less than $1,000 or hundreds of dollars. So what we are saying that with that, when it's less than $1,000, we are hoping that it'll be listed as a Class 1 misdemeanor.
Right. So, Senator Sproul, I think the thrust of your bill is that right now you cannot charge a conspiracy to commit a misdemeanor, and so except for one misdemeanor, I think, right? And you're trying to broaden that one exception, have a second exception for catalytic converters, and then
especially if it's
looks
under
like Mr. Qualiot is
$1,000.
trying to clarify what I'm trying to say. Why don't you
No,
say it
Mr.
better,
Chair,
Charles?
you're correct. The only misdemeanor you can conspire to commit is trespassing. So this would be a change in policy that would allow for conspiring to commit misdemeanor petty larceny for catalytic converters.
Less than $1,000, Mr. Chairman.
Got it. Okay. All right. So that's your approach. Senator Ruff, why don't you explain to us what your approach is and your substitute?
Thank you, Mr. Chairman. The way it started out, it copied essentially the North Carolina law. It's been worked on to try to satisfy everybody in the House. The problem is some of these things, replacement cost is up to $4,000. And it's not hard to snip them off and take off. So what we try to do is focus on the way we do pawn shops and other items like that where we're getting pictures. And we've already got that in part of the code, but this adds another section that deals strictly with catalytic converters and the parts thereof. So where they have to take pictures or have a video, you have to turn over information to law enforcement if they come. That is the thrust of it. The penalty part is whatever y'all want to make it, but that's the thrust. We worked with the salvage folks to try to make sure everybody was reasonably happy with it.
And Senator Ruff, am I right? I think you told me that your approach on lines 64 through 65 kind of parallels what we do with pawn shops. Is that right?
Very much such that way. And to be honest with you, this language is the exact same language that passed the House, because they had several versions and we had two versions. It felt like it was best to iron them out as soon as we could.
Okay, so I guess the committee has before it two different approaches. One sort of creates a new policy with regard to misdemeanors and, yes,
I do
sir.
have a speaker if you don't.
Oh, you do?
Yes, sir.
Okay. You want, before we make a decision, you want to have your speaker come and testify?
Yes, sir, please.
Okay.
It's the Deputy Chief from City of Chesapeake. She's been in Zoom.
Oh, on the Zoom?
Yeah.
What's the name?
Senator Spruill, could I have the name one more time?
Beg your pardon?
Is there a name for the testimony?
We didn't catch the name.
Yes, yeah.
Name?
Name is Mark, I pronounce that?
Mark Salsky.
Mark Solsky. Mark Solsky is in the room currently. Mark Solsky, would you please unmute and begin your testimony?
Yes, how are you? This is Deputy Chief Mark Selesky from the Chesapeake Police Department. Can you hear me okay?
Yes.
Yeah, the reason we submitted the amendment to 18.2-23 was for the reasons stated by Senator Spruill. We here in Chesapeake are experiencing a rash of catalytic converter thefts, as many localities are around the Commonwealth. And oftentimes, these crimes are committed by more than one person. While one person's underneath the car with a Sawzall cutting the catalytic converter loose, they have a lookout making sure everything's going okay. So what we aimed to do here was, in addition to charging them with the theft of the catalytic converter itself, be able to charge them as well with conspiring together to commit those thefts. And as Senator Spruill stated, oftentimes it's hard to determine the value of a used catalytic converter. So unless it goes over the threshold of $1,000, we don't have conspiracy to commit that theft at our disposal. So this amendment would allow us to do that by making, as was stated, conspiring to commit a theft under $1,000 punishable as a Class 1 misdemeanor.
Thank you for that, Mr. Selesky. Does anybody else have any testimony they want to give on the bill?
That's all I have.
Mr. Chair.
Okay, Mr. Uber
Shall I
Chair.
have one more? You don't mind?
Sure, go ahead. Make it quick.
Thank you, Mr. Chairman, members of the committee. David Westcott on behalf of the City of Chesapeake. We support the bill.
Okay, thanks.
Mr. Chair.
Other Uber Chair.
Ms. Senator Ruff, did I understand you correctly that the substitute represents the House, the approach taken in the House of Delegates?
That is correct.
Okay.
Senator Deeds.
Mr. Chair, I would move that we remove the lines 11 through 24 of the substitute.
Okay, is there a second for that?
Remove
I
24.
have a copy, Mr. Chairman, of the substitute, please.
No, he's talking about Senator Ruff's substitute.
I don't have a copy.
Senator Deeds, I believe, is moving to remove the criminal sanctions and leave the other stuff.
And I'll be honest, what I'm concerned about is that, and I'll be able to talk about further, is the notion, we've just made the policy decision to move the felony limit to $1,000, and we're making an exception to that 1 year in, and I'm a little worried about that.
Okay. Is there a second to Senator Deeds' motion? Okay, the motion's been moved and seconded. Is there any further discussion on the motion?
Mr. Chairman.
Senator Norman.
First of all, I would echo that this is a rash of problems, probably all over Virginia, but we're really getting hit hard down in Hampton Roads. And secondly, there are two aspects of it. One is the larceny provision of the catalytic converter, which can, right now, in this day and age, can run $1,000 to $2,000 depending upon the supply chain. But then there's a residual damage that is being done to the vehicle because they're not coming in there with a scalpel and being surgical in the way that they're removing it. And I object to the removal of line 24. I'd like to help my brother by a different mother. I don't like that conspiracy part.
We cool, Doc, we cool.
Yeah, Senator Norman, I would also just note, though, there are residual criminal sanctions available for damage to property if, depending on the value of the damage, and with most thefts, the replacement value of the item stolen is usually a lot more than the value of the item that was actually stolen. If it's an old item versus a new one. But, in any event, I'm sure the House of Delegates won't agree with our approach, and we can continue the conversation. And so the motion, I guess, is to strike lines 11 through 24 from Senator Ruff's bill. It's been seconded. All those in favor say aye. Aye.
No.
Okay. All those opposed? We have one no, and then how many proxies? Senator Norman?
McDougal's no.
And Stanley?
Stanley's no.
Got it. Okay. That's been stricken from the bill. Senator Sproul, I detect a vibe up here that the committee kind of prefers Senator Ruff's approach to the conspiracy approach. Would you like to be rolled into his bill and become a chief co-patron so you can get some credit?
Mr. Chairman, one part that the Deputy Chief read about the person, we were talking about the person who actually committed the crime, but it does not address as far as the misdemeanor for the person, the lookout person. So I'm trying to figure out that when the Deputy Chief talked about that, the person who is the lookout person, and this what he is doing, I agree with this, no problem with this. I agree with that 100%. I'll do that. Then, but what about the person who is the person who is watching out? So that's what the Deputy Chief is picking up. So if y'all can fix that part, then I'd be happy.
Got it. Senator Edwards, do you have something you want to say?
You can do aiding and abetting without conspiracies. I mean, it's not unusual.
Okay.
Mr. Chairman, can you talk layman's term, not lawyer's term to me, please?
I think what he's saying is he'd like to amend your bill by, instead of having the conspiracy language, having it say that anybody who aids and abets the theft of a catalytic converter would be guilty of a Class 1 misdemeanor. Is that right, Senator Edwards? Okay. Senator Sproul, do you like that amendment? Might keep your language alive.
That's my lawyer. That'd be all right? Yes, sir.
Okay. Senator Edwards is, I guess, Charles, do you understand that motion?
Yes, Mr. Chair.
Okay, I think change it from conspiracy to aid and abet, Class 1 misdemeanor. Is there a second for Senator Edwards' motion?
Second.
Okay, it's been seconded. All those in favor say aye. Aye. Anybody opposed? Okay, it's unanimous. Now, Senator Sproul, we got to roll one of you guys into the other. Who wants to go face the House of Delegates?
Could we be cool?
Sure.
Yeah.
Sure.
Mr. Chairman, I'll suggest we be cool and let him go talk to the House delegates.
Okay, all right. So is there a motion to roll Senator Sproul's bill into Senator Ruff's bill? They both be listed as chief co-patrons, and that Senator Ruff's bill have Senator Sproul's language added to it.
I'm going to make that motion.
Is there a second? Okay, all those in favor say aye.
Aye.
Anybody opposed?
I move we recommend reporting and re-referring. Do we have to re-refer to finance? Yes. Okay.
Mr.
Okay.
Chair, I would say I'll run it by finance, but since it's just a misdemeanor penalty, there should no need to be on the finance.
Okay, we can change the motion when we get the full on Monday. So is there a second to Senator Deed's motion? Okay, all those in favor say aye. Aye. Anybody opposed? Okay, thank you, gentlemen, you're done. Next up, Senator Peterson, I believe, right? Yep. Okay, I'm sorry, thank you. Senator Boysko is in the hole. Can somebody tell her that? Oh, there she is, okay.
Okay.
And Senator Eben is I'm sorry, Boysko's on deck, Eben is in the hole.
Okay, this bill, I promise you, has nothing to do with the state bar. Okay. All right, this is Senate Bill 378.
Okay, Senate Bill 378.
And this has to do with a petition for modification of a criminal sentence. It is what has been known colloquially as the second look bill. And it's risen out of kind of the experience of one man writ large, Sean Winetta, who is a constituent of mine, who's here today, will testify, and really has almost been a poster child of rehabilitation, and someone who's come out of our DOC system and become an advocate as well as a business owner, and just someone I really admire, I can say that. And it also represents the experiences of other folks that are in the DOC system. And I'll give you one example. And I know most people think, oh, you grew up in Fairfax, you know, your life's set. I went to high school, played football with a guy who went to church. I mean, we knew each other when we were little boys. Was convicted of 2006 of a very violent sexual act. Didn't kill anybody. He was addicted to drugs. And on a sentencing scale of 5 to 20, or excuse me, of 10 to 30, ended up getting 26 years. And he's pulled 16 years so far. And he and I are in touch, and I actually tried to help him with a pardon application, which didn't make it to the finish line. Needless to say, his life has completely changed, and he's somebody I use that, you know, he's done 16 years, he's looking at another 10, and I just think somebody like that, and I in this case, I know the sentencing judge, I know him very well. I think this would be the type of situation where if he had a chance to get back in front of that sentencing judge, I think it might make a difference. Now, that's maybe that's the 1%, maybe that's the 5%, but this bill addresses that situation where after you've been sentenced and you've served either 10 or 15 years, depending on your situation, you have a chance to go back in front of the sentencing judge and basically show them where you are in your journey in life and get a second chance. And so I do have some paperwork, which I apologize, I should have passed this out earlier, if I might. It's just a one-pager, but this is what they call the second look bill, and I do have witnesses in favor, Mr. Subcommittee Chair.
Right. Senator Peterson, just so we're clear, this only applies to anybody who is 25 or under at the time they committed it. They have to serve at least 10 years, and they have to be of good behavior while they're in prison.
Right, or it's 15, you have to serve 15 years if you're over 25.
Okay?
And that's,
All right.
and these numbers are obviously up for whatever you all
And
think.
Senator Peterson, the victim is notified if there's any
Victim is
hearing?
notified, Commonwealth is notified, it's a 90-day process to get back in front of the sentencing judge.
Okay, thank you. Does anybody have any questions to the patron?
And I'd like to have Sean come forward, because it's really his.
Okay, Senator Peterson, how many witnesses do you have? I'm just trying to get a sense whether we need a timer on this.
I've got 1, 2, 3, 4, anybody else? People on the Zoom room. And some in Zoom.
Okay, then we're going to put a 5 minute and 5 minute, 5 minutes in support, 5 minutes opposed.
Take your mask off.
Good afternoon. Thank you for letting me speak. Sean Winetta on behalf of the ACLU. Together with several stakeholders, including Sisters in Prison Reform, No Left Turns, Sheba Williams, Justice Forward Virginia, we all put this bill together. It is out of stakeholders that put this together. People are directly impacted by incarceration, as well as people behind me. This is a transparent mechanism. We really wanted to be sure that transparency was built into this. We do task the Commonwealth Attorney with notifying victims. If they are unable to notify victims, then the Commonwealth has to file a pleading with the court, letting them know what measures they went to contact that victim. I received a pardon. I had a 30-year sentence for embezzlement. I served 16 years, and Governor Northam issued me a pardon. I worked very hard to earn that pardon. It was the only remedy that I had. Same with these other gentlemen that will speak today. There should be another mechanism. It shouldn't be on the back of a partisan actor, and this provides this transparent mechanism that brings everybody into the room. And I'm going to go ahead and leave space for other people to speak as well. Thank you.
Thank you for your testimony, Mr. Winetta. Who's next?
Benjamin Knotts, Americans for Prosperity. This is an important bill. When you look at taking people's livelihoods, we trust that there's a mechanism in the government to say, is it appropriate to still take this much of their livelihood, their taxes? We also need a mechanism to say, if we're literally taking people's lives, there should be some mechanism to make sure it's still appropriate to this day. And then we think this is a logical step for anybody that says we need government oversight. We need to make sure, at the end of the day, it's this. If you can trust the court to give the sentence, you can trust the court to review the sentence. And at the end of the day, that's what we think this is appropriate. As many people it's going to impact, we think it's very little a risk to the public, and it really does err on the side of our citizens that we trust and we love. Thanks so much.
Thank you for AFP's testimony. Who's next?
How y'all doing today, sir? Yeah, my name is Angel Reyes. I was just pardoned by Governor Northam after serving 27 years as a juvenile. And this is kind of like the only way that I actually had a way of coming home, so to speak. You know, I don't come here today to tell you that these are the reasons why, you know, this bill should be passed. I'm here to tell you that this is the reason why this bill should be passed. This is what change looks like. 27 years, had a life sentence, never thought I would ever make it home. And this is with all due respect to the victim's family. I support this bill for so many different reasons, but I'm not going to hold y'all up. I'm just here to say that this is what change looks like. And this is the reason why this bill should be supported and passed. So many things I could say, and I know y'all don't have that much time. But I want to say from the bottom of my heart, thank you. Thank you for supporting the juvenile bill that was passed in 2020. And there's so many other things that need to happen because nobody knows what 25 years from now is going to look like. So just think about that. You know, I was serving a life sentence without a second chance. And I did everything I could in prison, 22 years infraction free. You know, so it can happen. It can happen. And it's a lot of brothers in there that's still in there and are voiceless. So I'm here for them. And thank you.
No, sir, hold on 1 second. There's one question for you from the podium. Yeah, can you stop the time?
Yes, sir.
Senator Norman.
Yeah. Congratulations on your transformation. I don't mean to embarrass you, but what was the underlying conviction that gave you the life sentence?
First-degree murder.
Okay. Thank you for your forthrightness, sir. Appreciate
No problem.
Thank you for testifying today.
Hello, I'm
Thanks, sir.
Sincere Born Allah, recently released by Governor Northam on a pardon as well. I'm here to support Senate Bill 378. I'm the embodiment of what second chance looks at life looks like. Thankfully, former Governor Northam and his administration acknowledged my growth, believed in me, and granted my clemency, essentially saving my life. Not being identified by my worst mistake and adolescent impulsive behavior that led to my incarceration at 18 years old, 24 years ago, is a blessing I earned as a result of my corrective thought and action, as well as my conscious decision to think and conduct myself in a positive, constructive manner, both of which happen to be in the public outline and philosophy of this justice system and the Virginia Department of Corrections. Exorbitant, no parole sentences with no hope, no help, and no chance is a spirit killer to that specific philosophy of the individual, our families, and our communities. The collateral consequences of prolonged incarceration are far-reaching and at times irreversible. The 90s era tough-on-crime ideology has been a disaster nationwide, only increasing prison populations, and has not made communities safer. Just look at the state of emergency here in the city of Richmond right now due to gun violence by inner-city youth. I'd like to end with a rhetorical question. Has anyone in opposition to this bill ever seen a hopeless and helpless man? Because for the last 24 years I did. I firmly stand in support of Senate Bill 378.
Thank you, Mr. Olive. Please say hi to Ms. Belton for me. Is there anybody opposed? I'm sorry, there's a whole bunch of people in the Zoom room. Can the people in the Zoom room just please state your name? If you're with an organization, can you say the organization and say, I guess, that you support or oppose the bill? I assume these are all support.
Juanita Belton, would you please unmute?
There she is.
Hi, Senator Servos. Juanita Belton, one of the co-founders of Citizen Prison Reform. Sincere and Angel said enough. We wholeheartedly support this bill. We are stakeholders in this bill, and it's time to acknowledge that people are able to really rehabilitate in prison, and that they earn the way home. Thank you.
Thank you. Next.
Molly Gills, please unmute.
I'm Molly Gill. I represent FAM, a nonpartisan nonprofit sentencing and prison reform organization in Washington, D.C., and we support this bill.
Thank you for being brief. Next.
Ramin Fatahi, please unmute.
Good afternoon, members of the panel. Ramin Fatahi from the Norfolk Commonwealth Attorney's Office. I'm in support of this bill. Prosecutors generally have to seek the sentence that will keep the community safe under the assumption
Mr.
that...
Mr. Fatahi, can you say whether you support or oppose the bill?
Sorry, hopefully this is better. I support the bill.
Okay, thank you. Our time's expired, so we have to move it along. Okay, next.
Thank you.
Genevieve Miller, please unmute.
Genevieve Miller, Deputy Public Defender in Prince William County, here on behalf of Justice Forward Virginia in support of this bill.
Thank you. Next.
Victor McKenzie Jr., please unmute.
Victor McKenzie Jr. with the Substance Abuse and Addiction Recovery Alliance of Virginia. We support the bill.
Thank you. Next.
Santia Nance, would you please unmute?
Santia Nance of Sisters in Prison Reform, and obviously I support this bill.
Thank you, Ms. Nance. Next.
Sheba Williams, please unmute.
Sheba Williams, no left turns. We support the bill.
Thank you, Ms. Williams. Next.
And James Banks, would you please unmute? James Banks, would you please unmute?
I think the names might be confused. This is Alexandra Bailey with the Sentencing Project. We support the concept but oppose the language.
Okay. Thank you, Ms. Banks. is there anybody in the room who opposes the bill? Can we put a 5-minute timer on that?
Thank you, Mr. Chairman. Nathan Green, Commonwealth Attorney for the City of Williamsburg, James City County, speaking on behalf of the Virginia Association of Commonwealth Attorneys. And really feeling that it's our responsibility to come and speak on behalf of the victims of these crimes. If we are talking about people serving sentences of 10 years, 15 years, we are talking about the most egregious crimes that our communities have faced. We're talking about murder and rape, sexual abuse of children. And when they came to court and we told them, well, we're ready to make this offer to this individual. If they take this offer, here's what their sentence will be. Or we got them to come in and testify at a sentencing hearing and said, this will be your time. Once you testify here, you can start to put this behind you and get on with your life or get on with the loss of your loved one. That will make us all liars. We will now be bringing these people back into court, back before a judge, not just once, but it looks like about every 3 years if a petition isn't granted the first time around. And these individuals will have to go back through these experiences yet again. I do understand that people can change and can be rehabilitated while in prison. But what can't change is when someone has lost their loved one to a crime of violence. That individual cannot come back. That individual cannot be rehabilitated. Those families have to deal with that loss with no hope of it changing in any way. This is an anti-victim. This is a bill that would make these individuals relive these horrors when we promised them that it was going to be done and that their sentence was going to be set. Thank you.
Okay, thank you, Mr. Green. Next up, the Attorney General's office.
Mr. Chair, members of the subcommittee, Mr. Green did a sufficient job explaining our concerns with the bill, and we oppose.
Okay. Is there anybody else opposed in the room? No? Is there anybody opposed in the Zoom?
Mr. Chairman, there is one hand raised.
Okay, we have 2 minutes and 45 seconds for the one hand raised in opposition.
Francis Ross, would you please unmute and begin your testimony?
Hi, Chairman and Senators. I'm sorry, my hand was raised. I'm actually in favor of this bill. My name is Francis Ross, and I am from the Residents of Virginia group, and we have 1,400 members, and we support this bill and think that everybody deserves a second look. Thank you.
Thank you, Ms. Ross. Okay, so there's nobody else in opposition. All right, Senator Peterson, you want to wrap it up?
Yeah, I
How many
do.
other states have this law?
Maryland approved Senate Bill 494, which allows a petition for resentencing after 20 years, once you turn, but it's before their 18th birthday, then 20 years.
Senator Peterson, I believe there's a law in Texas, too, isn't it? Am I not
Yeah,
mistaken?
D.C. has a second look. Individuals sentenced under the age of 25 petition the courts for resentencing after serving for 15 years. Let me just address a couple.
Senator Peterson, Senator Norman has a question.
Yes,
Do you want
sir,
to take that
please.
before you wrap up?
Yes, sir.
Thank you very much, Mr. Chairman. Does this reconsideration include sentences that were imposed by someone selected a jury trial?
Yes.
So basically nullification of a jury's decision on punishment.
Well, after they serve 15 years.
After it's been approved by a
I
judge, I would
understand
know,
what the
Mr. Senator.
criteria is.
Senator Norman.
That's all I have. Thank you.
Yeah, just, and if I might, and I'm, obviously we're starting a process. It's not three, it's you get two opportunities, and quite frankly, look, if I got limited down to one opportunity, we'll go with one opportunity. The other thing is, the age 25, obviously that's my version, but I need to move this concept forward. I think the concept makes a lot of sense, and I think the witnesses today were terrific. I really wish I could really just, they were terrific. So I hope you all will at least allow us to move forward.
Thank you, Senator Peterson. Chair will entertain a motion. Is there a motion? Report and re-refer. I can't make it.
Second.
Okay, Senator Deeds moves the report and re-refer the bill to finance, seconded by Senator Edwards. Okay, substitute motion takes priority. All those in favor of PBIing the bill, please say aye. All those opposed? No. McClellan's no. Yeah, so
Can I run that down the line, sir?
Yeah, it's party line, except Morrissey's not here.
All right.
Copy that.
The remaining motion, the primary motion before us is move to report and re-refer to finance. All those in favor say aye. Aye. McClellan's aye. All those opposed? And Stanley's no. Okay, so the bill, we were going to recommend the bill be reported and re-referred to finance. Thank you, Senator Peterson.
When will it be heard in front of the full committee?
Monday. Yeah.
Thank you.
Yeah. And we've had the hearing here. We're not going to, I think the idea is not to take more testimony, evidence.
Thank you.
Got it. Okay, next up, we have Senator Boysko, and Senator Eben is on deck with 643 and 310. If we get done with that, we will go to Edwards.
Thank you, Mr. Chair.
Senator Boysko.
Thank you, Mr. Chair. SB 440 updates and strengthens our criminal laws on hazing. This is the companion bill to the education bill we just passed out of the Senate unanimously. My constituent, Adam Oakes, was a 19-year-old student from Loudoun County. You've heard the story, but I'll say it again. He was found dead on February 27th of last year in a house the morning after a Delta Chi fraternity party. He was hazed the night before and told to drink a handle of Jack Daniel's whiskey, which we all know now is the equivalent of 40 shots. While we already have anti-hazing laws in our code, and Senator Norman certainly has had a big hand in that, as well as Senator Saslaw, they have not been updated since that time, which was 2014. And the stakeholders and I have worked together all year. We believe that we must strengthen the criminal code also to effectively eliminate hazing. Adam's father, Eric, and his cousin, Courtney White, are here with us today. They are committed to strengthening our laws so other families don't have to go through the tragedy that they've gone through. I'm happy to go through the bill if you would like, or if you would like to take their testimony first, it's your pleasure.
Senator Boyce, I have a question. So how much testimony, do you have any testimony in addition to the family?
I have the two family members, and that's all.
Okay, I'm just trying to get a sense
I'm aware of, yeah.
time. But yeah, it's a very, the bill adds a lot of new words to the code.
Yeah, it's a complicated bill, and I know that Charles is here ready to answer technical questions.
Okay, why don't we hear from the parent? Senator Deeds, you have a question?
I was just going to ask staff about this language on line 93, where you cause another person to suffer severe emotional distress through outrageous or intolerable conduct.
Mr. Chairman, Senator Deeds is correct that presents a constitutional problem. A principal tenet of criminal law is that the criminal law must be so unambiguous that everyone understands what conduct is prohibited by the criminal offense. And criminalizing outrageous or intolerable conduct, many, many times we will all agree what is outrageous or intolerable. But there are also many times when people will be uncertain as to whether their conduct crosses that threshold. So using this language, I'm afraid, would cause the offense to be an unconstitutional criminal offense.
Senator Deeds.
It's almost like Potter Stewart said, you know it when you see it, but there's not really a good way to define it. How do you know for certain what is or is not outrageous or intolerable?
Mr. Chair, I would just add that these are the elements
Mr.
for intentional infliction of emotional distress. There are certain subsets of states around the United States that are importing that particular tort into crimes related to hazing and stalking. Steve's points are well made, but I'm not sure it rises to the level of unconstitutionally vague, as there are a number of states that are doing this, and courts have already figured out what the elements of intentional infliction of emotional distress are. So I think it's more of a policy issue than necessarily a constitutional issue.
Okay,
Madam Chair.
Mr. Chairman, Sir Chairman, I think, first of all, I think we ought to have the legal discussion after we take the testimony. I think there's definitely a legal discussion to be had, and that's one of the difficulties presented by the bill. So why don't we hear from the parents, your witnesses, your constituents, and then, I don't know if you want to tell us why you think the bill's not unconstitutional, or you want to take a shot at that or not, let us
Okay.
argue it. But why don't we hear from your
Great.
constituents?
All righty. So I have Courtney White and Eric Oates.
Hi, my name is Courtney White. I'm the cousin of Adam Oakes, the most recent hazing victim in the Virginia Commonwealth University. The reason I'm here with you today is to advocate for a change in the current law against hazing. To start, the medical examiner calculated Adam's BAC at a 0.419, 5 times the legal limit, and reassured us that had any one of the 20-plus men there that night gotten him help, he would still be alive today. They knew he was in trouble, and yet they failed to render help. Over the past year, we've been fighting to have those involved in his death convicted of hazing, providing alcohol to a minor, and failure to render care in a time of need. Literally fighting day in and day out to have punishment for what happened. We've been pushing to transform the current hazing law in Virginia to protect others of the same fate as Adam. 11 Delta Chi brothers have been charged with hazing in relation to my cousin's death. One, his big brother, has pleaded guilty so far. However, the punishment, a Class 1 misdemeanor with a possible of $1,000 fine and a year in jail, just does not fit the crime. Hence why we need to develop a better bill where it does. How would you feel if the people involved in the death of your son, daughter, grandchild, or loved one walked away with a slap on the wrist? To my aunt and uncle, they lost the light of their life, their only child, and their reason for living. The people responsible for Adam's passing will walk away, celebrate holidays and birthdays with their families, get married, have children, and build a future for themselves, while my cousin will permanently be 6 feet underground and never get to follow his dreams of being in sports marketing, of having a family of his own, or having the ability to grow old and enjoy life. We cannot save Adam, nor can we change the punishment for these boys in his case and truly hold them accountable. But we can enhance the current law to protect others. Others like Marvell Edmondson and Juwan Holmes, that both died at Virginia State University in 2013 because they were forced to walk through the Appomattox River at 1 a.m. The river swept them away and both men drowned. Juwan's mother, Dionne Williams, is watching right now, virtually, and she is in support of this bill. The perpetrators got suspended sentences in their deaths that were 3 to 4 months in jail. That's it. U.S. campuses have experienced at least one hazing death per year since 1959. Virginia has had 10 hazing-related deaths, and none of them have spent except 3 to 4 months in jail for hazing someone to the point of death. The only exception was 2020 when kids weren't even on campus. There have been over 100 U.S.-related hazing deaths in the in the nation in the past 15 years. In this year alone, Adam is one of 5 in 2021. That's the most since 2017. 12 states now have felony hazing laws. 2, Arizona and Washington State, there were 2 other states that filed the same bills that we have in front of us, or similar to it, to the one before you. One possible solution to eliminate hazing is proposed in Senate Bill 440. This bill would enforce harsher penalties and possibly deter the behavior. This isn't just about Adam. It's about honoring those that we've lost. And it's about those we need to protect, our children. You all have the extraordinary power to protect and save children's lives by engaging in this change.
Thank you, Ms. Stokes.
Hello.
Thank you, sir. If you could keep it to 2-3 minutes.
No problem.
Yeah, thank you.
I just want to thank everyone for hearing us, and I want to just mention how this legislation can help save lives. Adam's death was so senseless and meaningless. We feel that the law in Virginia needs to be stiffer for the purpose of deterring this type of behavior. Hazing is a cruel and outdated practice of showing who's in charge and using that leverage against the most vulnerable. This law change will affect not only those in fraternities, sororities, but prevent teams, clubs, organizations, and associations from killing or seriously injuring prospective members by hazing. Hazing is a vicious cycle. The because it happened to me, because I was a pledge mentality is no excuse. We don't accept that in our society. It's not a defense for molestation, child or domestic abuse, and physical abuse. You do it because you choose to, and that you should be held accountable to the fullest extent of the law. Hazing is nothing more than a brutal, too often fatal, higher education form of bullying. In May, we started a foundation called the Love Like Adam Foundation that will educate rising seniors that are going to college about the dangers of hazing and how to identify it and report it. Hazing has drastically changed over the past few years. Most young adults aren't even aware that they've been hazed. Through the proper training, we will help them identify it and teach them how to protect themselves before they start college. And companion legislation recently passed by the Senate, SB 439, Adams Law, will ensure that organizations empower students to address hazing once they're on campus. Our goal is that no other child must lose their life due to hazing. I feel strengthening this law will deter people from hazing, and if you do, there will be a stiff penalty. I am determined to make Adam's death the last one in Virginia due to hazing. As we enter the new year, the goal is let's make meaningful changes. It all starts with you. We need your support to implement this bill into law. We can't do it alone. I'm here today humbly asking you to please support this bill and let's make it a law. Thank you.
Thank you, sir. We appreciate you and your niece's testimony. You know, the committee offers you, deepest condolences, and, nothing we do today or anything this session could ever bring back your son, but
Understood.
can
Thank
appreciate
you,
your
sir.
quest to
Just trying to
achieve
save the
justice
next
for him.
life. Thank you.
Yep.
Mr. Chair, I'm
Senator
just trying
Deeds.
to understand, I still don't understand how you prove beyond a reasonable doubt that somebody's guilty of outrageous or intolerable conduct. I'm not certain what standard you have there, and so I would move to strike, after the word activity, I'd put a period, and I'd strike the rest of line 92, 93, and 94.
Yeah. Mr. Chair.
Senator, hold on. So we have a motion. Senator Edwards, is this to that point?
Yeah. Let me say, I've won in a civil case, intentional infliction of emotional distress, but I'm not sure that's the proper. I haven't seen other states doing it as a criminal matter. There, I actually won a big verdict one time on intentional infliction of emotional distress. At the same time, I also have prosecuted some hazing cases. In one case, I defended a hazing case involving brothers at a certain university in Radford, and the prosecutor prosecuted most of the people in the fraternity. I think he prosecuted them, if I'm not mistaken, for manslaughter. Would manslaughter work from the criminal standpoint, Steve, or Charles?
Yes.
Yeah, that's what I'm thinking. There's an adequate, I don't know the facts of this case completely, obviously, but I would think that would be the appropriate criminal issue. But from the hazing standpoint, I like the fact that you're getting the organizations involved. The best thing about hazing is the organizations need to be being taken responsibly. And the cases that I brought on behalf of certain brothers and some well-known universities in the western part of the state and colleges, the universities just shut them down. Once they heard what was going on, they just shut them down and on their own. And I think, and the others, my clients were hazed, and to the point that it affected, they didn't die in this case, but it affected their health, their grades, and a lot of other things. Funny thing about 19-year-olds and 18-year-olds, I used to ask them, why did you do this? I mean, how stupid is this? And they looked at me and says, I thought I had to. My friends were doing it. I thought I was supposed to do this.
Yeah.
And so, I think having some sanctions on the fraternities and organizations is a good idea too. But I think the criminal matter, I don't know why manslaughter isn't an adequate criminal remedy as opposed to intentional infliction of emotional distress. Charles.
So, Senator Deeds, is that a question to the council, or what is that?
I think it's a question, Mr. Chair.
Okay, thank you.
What I would say is, and there may be since the committee has already struck the intentional infliction of emotional distress language.
We haven't done that yet.
I thought it was adopted, but.
There was a motion made.
I would also then suggest to follow Senator Edwards, the Uber Chair's comments. The committee also may want to strike, if it believes that manslaughter is a sufficient deterrent and penalty, also on lines 42 to 43, the heightened class 5 felony resulting in death, which is essentially the same punishment as voluntary manslaughter, or involuntary manslaughter, which would probably be appropriate.
Counsel, but I'd also note, I mean, serious bodily injury is not even defined in this statute, is it? I mean,
It is not.
To use the same words as we use for malicious prosecution, but has a whole class of law and decisions telling us what it is, but this
Right.
doesn't even define it, right?
Well, this does appear in the same article as a malicious, so I'd have to look at the definition to see if it applies to the entire article again off the top of my head. But this does appear in the same article as malicious prosecution. But to your point of, if you were just restore all that language to just being guilty of a class 1 misdemeanor, and leaving in the provision that this section shall not preclude prosecution under any other statute, that may resolve the issue.
Yeah, that makes sense. That'd be my motion.
Okay, so, hold on. So I think Senator, Mr. Uber Chair is amending the other Uber Chair's motion.
Chairman.
Okay, Senator McDougal, before we clarify motion.
All of us up here who've practiced in the criminal law area kind of understand, but I don't think Senator Boysko understands that by doing that. What you're saying is that it is clear that you could prosecute for the separate charge of manslaughter, involuntary manslaughter.
Correct.
Right.
So even though you're not listing it out, it might actually change your fiscal impact to help you out along the way as a side effect, but it does make it clear that you could bring that other charge, which is not clear right now.
Right, so, and Senator, just so I can try and summarize where I think the conversation is right now, I think the idea is to strike out the reckless, intentional, intolerable, outrageous, severe emotional distress language, strike out the class 5 felony so that involuntary manslaughter is available, leave it a class 1 misdemeanor, but you can prosecute as manslaughter if it's bad, and keep your safe harbor and keep your civil stuff. I think that's the general idea where we're trying to go here.
Right.
Is that, committee members, is that kind of where we are?
I think so.
Okay.
It is.
So this is what, I think Senator Deeds is accepting some friendly amendments to his motion. So Senator Deeds moves, Senator Edwards seconds that we strike, first of all, lines 92 through 94, the new language there from the bill. Number one, that we also strike all the changes on lines 41 through 43 from the bill, right? And is that it?
I think that's it.
I think that's it.
That's it,
yeah.
Senator Voisko. We just want, if we want, it's not good enough to just pass a bill. We want something
Right.
that's going to work.
And I want it to work too. If you could help me, this is unusual where I'm the one asking the question instead of you asking me. So, I mean, one of the things that we were concerned by is that the way the law is currently, they get a class 1 misdemeanor and that's pretty much it. We were saying that if somebody, you know that they are setting out to make somebody drink 40 shots, that they should be charged at a higher. So I just want for them and for everybody listening, if you could just re-clarify what the punishment would be for.
The language you've got, the provisions of this subsection shall not preclude prosecutions under any other statute. That's new language.
Okay.
That means. that it-
Mr. Uberchair, that's not what it says. It says no person be subject to arrest or prosecution violating this section. So they could be subject to prosecution for voluntary manslaughter. So you need to tweak that safe harbor a little bit if you're intending to broaden it to a felony charge.
Well, but it doesn't preclude prosecution under any other statute. So what it means, in my view, is you can still charge somebody with manslaughter if the conduct results in somebody's death. You can still charge them with manslaughter.
Yes, you can.
And currently they can't. Isn't
That's
that
right.
correct? And what is the penalty for manslaughter?
It's a class 5 felony.
So it
It's the
would
same
be
thing.
the
Looks
same
like-
thing.
I think
Okay, so
Mr.
for anybody who's
Qualiato-
listening,
I think Mr. Qualiato is trying to say something.
Right, just so, the safe harbor provision, the cry for emergency help will only apply to the hazing charge, just so we're abundantly clear. But it also, by including the not preclude language, you are allowing charges for manslaughter or other malicious woundings to go further. That's unclear right now in the hazing statute. So we are adding language that clarifies other charges can be brought.
That the safe harbor does not apply to.
The safe harbor does not apply to the other charges, just to the hazing charge.
Okay. So that if somebody's in really bad shape, the safe harbor wouldn't help them out?
That's correct.
Mr. Chairman, if you wanted the safe harbor to apply to manslaughter, that would be a simple drafting addition on line 47.
Okay, what's the committee's temperature on that? Because I'm not sure the safe harbor does a lot of good in these scenarios if you can still be charged with a felony for it. Because I think the original bill that Senator Boysko proposed would have a safe harbor for the felony.
And
But I
Mr.
mean, when a situation like this happens, I can imagine, aside from the fact that a lot of people might be intoxicated and not really have a good appreciation of what's going on, you might not really know the full condition of the victim or where the victim's going to end up. And so I would think this, I'm not sure the safe harbor would do a lot of good in that scenario. So it seems to me, at least, we ought to think about it applying to the felony. What is the committee's temperature on that? Anybody have any thoughts?
And Mr. Chair, I'll just say that with the safe harbor, we were hoping that someone who is a bystander who sees what's going on could call. They would not be in trouble. They would save the person's life. That's the intent behind that.
Right. Right. That's kind of what I'm getting at.
And hopefully they would do it before the person died so
Senator Norman,
that.
or was it Senator Edwards? I heard noises out of.
I think safe harbor, what happened, I could give the story in Radford. The guy died for drinking too much. And they could easily have, they didn't call because they're afraid of getting caught.
That's.
For, drinking, underage drinking.
Right.
And that's why the guy died. If it just called
Okay.
somebody sooner, he would have been probably
Okay.
alive.
And that's.
Council, what kind of language would we have to do to broaden it to felonies?
Mr. Chairman, I think we would want leave to workshop that, but on line 47, you would add language so that it read, "No person shall be subject to arrest or prosecution for violating this section or for causing the death of another." But again, I want to double check that to make sure we get it right.
All right, yeah, Mr.
I
Chair.
would think we wouldn't want it to include murder, though. Right? So, I mean, it would have to be like an unintentionally.
That's why we want to workshop it,
Yeah.
to make sure we're getting at what the patron intends.
If that's we can definitely have language ready for Monday, if not earlier on Friday, if this committee is to meet on Friday, just to get the
Got it.
approval of this.
Okay, so I'm just trying to get a sense of the committee here so we can figure out how to structure a motion and a vote. I'm not sure where everybody is on the safe harbors. We might have a separate vote on that, but, so Senator Norman, I see you have your light on.
No, it
And I-
just makes me a little uncomfortable. This is a little bit of a tricky situation, and I appreciate that the non-lawyers in the audience don't really understand what we're doing. And I mean that in a sympathetic,
Sure.
empathetic put away, but we're dealing with a little bit of a tricky situation here, and I really think we need to get the language straight.
The language absolutely
Senator
has to be
Deeds.
right. And we can either, it seems to me, we can make amendments in concept and look at them on Monday. If they work, fine. If they don't, it seems to me we've got to study this for a longer period of time.
Yeah, I just.
Okay, so why don't we do this in two pieces? So why don't we do Senator Deeds' motion to strike the changes on 41 through 43 and 91 through 94 out of the bill? Why don't we do that first? All those in favor of that motion, say aye. Aye. Anybody opposed to that? Okay. Now, on the safe harbor, does somebody have a motion to make the safe harbor apply to any situation that unintentionally causes a death subject to wordsmithing?
I will make that motion in concept.
Okay.
Mr. Chair, before you move on to that, I just want to make sure that I understand what you're doing, because the intention is, this is the concern that we have, that I am in charge of the hazing, and I then force the kid to drink everything under the sun. And when I realize that he's dying, I get off on it because I am going to be immune. We want,
Only because I call the cops or I call the rescue squad.
And if you don't give some kind of immunity there, they won't call anybody. That's what happened.
I just want to make sure that
in
we
the
all
case
hear
I
what
was
we're saying
involved in.
here.
Well, I mean, it wouldn't be an excuse for an
Senator Dees.
intentional murder. I'm sorry. It wouldn't be, if you're intentionally, but it would, for an accident or for an unintentional act, that's all, it would be a safe harbor for that.
Thank you. I just
Yeah.
want this to be clear as a bit, clear as we can get it so that people understand
And
what
it's only a
you're.
concept now. We don't know that we're going to have the language.
Okay.
On Monday, we might look at the language and say that's not what
It's not
we
going to work.
intended.
It's not going to
Mr.
work or whatever.
Mr.
Yeah, Senator
Chairman,
McDougal.
I don't want to, I just want to express a little bit of concern. I know we did this type of provision for individuals who are overdosing together and calling for help. This seems just a little bit different to me, this same type of provision. So we definitely we don't want to do anything to discourage somebody from calling law enforcement or calling for EMS or providing CPR. I'm not sure I'm convinced that this is an analogous situation that we want to do the hold harmless the same way.
That's why I was asking for the temperature.
Yeah.
Senator McDougal.
My temperature's lukewarm.
I got it. And, we're under a time crunch here, so we're trying to get something done while we can. But I appreciate that. And I'm sure there's other people in another part of the building that if it ever gets there will have a lot of questions and concerns also, and probably seeing this back again. But did everybody hear Senator Deeds' motion that I believe, I seconded for Senator McClellan. Now she's back. Okay. All those in favor of that motion and concept for our lawyers to work on and wordsmith? All those in favor say aye.
Aye.
Okay. Anybody opposed to that motion? No.
Okay, it's amended. I move that we recommend reporting and re-referring to finance.
Okay, so there's been a motion to, actually, I'm sorry, I haven't taken opposition. Is there anybody in opposition to the bill?
Mr. Chairman?
1 second, Senator McDougal. Is there anybody in opposition to the bill? Just clean,
Mr. Chairman, there's no one online.
check that box. Okay, Senator McDougal.
Mr. Chairman, we talked about the criminal provision, but we didn't talk about the provision of the Commonwealth's attorneys in being involved with the presidents of the university. I'd like.
And Mr. Chair, I can answer.
Okay, Senator Boyska, why don't you explain that?
Sure. So currently, a president of a university is at risk for other things like FOIA violations. We did check this out. This was a concern as we were drafting the bill. Some of my colleagues on the House side had expressed a concern, but already the president of any school or institution receiving appropriations. Just trying to find it, I'm sorry. Appreciate you giving me a second.
Mr. Chair, I think I can at least help the
Okay.
patient a little bit.
Mr. Quagliano?
Under subsection D, the president of the university has certain requirements placed on him.
Yeah.
Which is to discipline a student who is convicted of hazing, as well as to notify the attorney for the Commonwealth of all instances of hazing. The subsection E essentially provides that a person can file a mandamus action against the president to compel him to do those non-discretionary acts. That's the explanation for it. Whether the policy is of sound, that's for the committee to decide. But that is what it does and the intent behind it.
Yeah.
Mr. Chairman.
Senator McDougal.
I mean, so if I guess, what other types of opportunities do we give any person, whether they live in the United States or not, the ability to pick the venue, go in general district or circuit court, and do we typically file mandamuses in injunctions in district court?
I would say there's one example I can think of, which is homeowners associations. Other than that, I can't think of any. Maybe council can.
The FOIA is the other example where you can
Mr. Chair,
file in general district court.
We filed that in general district. Well, what?
Senator McDougal.
It would seem to me that, number one, we'd pick one or the other. We'd pick general district or circuit. We wouldn't do both. And the any person seems overly broad. I don't guess any person can file under the homeowners association. It's somewhat limited. The attorney for the Commonwealth would be more focused in filing in district court.
Senator McDougal, is that a motion?
Yes.
Okay, Senator, is there a second to that motion? You're trying to strike any person, right? You're just basically trying to strike any person, including, right?
Mr. Chairman, I guess I don't know that you would need the acting in his official individual capacity. I would think you would just have the attorney for the Commonwealth.
Mr. Chair, yes, that's correct. So.
Okay, is there a second for that motion?
I'll second it.
Okay, is there any more discussion on that motion? Senator Norman, your light's back on.
My light goes off because we are rewriting so much of this bill on the fly in concept, and I have great respect for the other attorneys on this subcommittee, but this is perilous.
Senator Norman, I appreciate the fact this bill is not a minor bill, and it has a lot of potential to affect a lot of people. And I agree with you that we need to be careful about how we do anything involving criminal statutes or mandamus or anything. Especially, I think Senator McDougal's catch there is an important one. It basically grants standing to anybody on the planet to file a mandamus against a university, and that's a big deal. Yeah, I get it. But Senator McDougal's motion, is all those in favor of his motion, say aye. Anybody opposed? No, okay. So, Senator McDougal, do you have anything else on lines 75 through 86 you want to bring up? You sounded concerned about it in general, but no. All right.
Mr. Chairman, I have not focused on the lines 95 and below. So maybe if we could talk a little bit about.
Senator Boysko, can you explain that?
That seems not to be in the criminal subcommittee in which we are. That's why I don't like us being broken up, my editorial comment, into subcommittees. I think we should meet as a full courts committee. But that being said, that's probably, that's a whole nother concept.
Are you talking about the 18.2-56.01
Yes.
portion? I am going to phone a friend and ask Charles if he could help us work through that.
So, Mr. Chair, this section of the bill was designed to get at more of the organizational structures that may have hazing occurring within them, and essentially providing a civil penalty that if they have a specific, I believe it's specific credible knowledge that its members are participating in hazing, that and they fail to prevent such hazing, that it makes a civil penalty to local organizations, national organizations, and essentially the institutions of higher education, if the agents or employees know or the governing board knows.
And Mr. Chair and members.
Senator Boysko.
There have been problems with this fraternity that Adam was proposed to join before. And this is an attempt to discourage the organizations to quickly readmit them when something tragic has happened. I guess that's the nice way of putting it.
Senator Boysko, I think what this bill would do, though, if we were to pass it, would give a local Commonwealth attorney authority to go swear out a civil summons against a national fraternity in a general district court and then proceed to trial and get up to a $50,000 fine against them. Is that right?
That's correct, Mr. Chair.
That's a pretty big change in policy. Senator Norman.
This bill is getting more problematic by the second. What we are attempting to do, and I appreciate she's not an attorney, and God bless her. Now we're talking about statutorily embedding vicarious liability on a national organization. Not good. Not good as a matter of a statutory provision.
Mr. Chairman.
Senator McDougal.
So just a full disclosure, I was never in fraternity. I think you were when we were at JMU, and so I've probably said negative things about fraternities in my life, but just like specifically, isn't the jurisdictional limit of district court 25,000?
It's $50,000 when it comes to certain personal injury cases, but for everything else, it's 25. Yeah, and Senator McDougal, let me cut it short. I mean, I think I'm getting the sense that there's some discomfort with this section of the bill, and so is there a motion to strike 95 through 123? Okay, is there a second to that? Okay. Senator Boyska, you want to defend it one last time?
You know, national organizations are operating in Virginia. There's no way for us to hold them somewhat responsible. This is an issue that really is baked into these organizations.
Mr. Chair.
And we're easily just saying like, sorry, it's too hard to prosecute them. They have a blind eye on a lot of the time. I mean.
Mr. Chair.
Senator McClellan.
Thank you, Mr. Chair. As someone who is a member of a sorority that's one of the Divine Nine, and this is an issue that our fraternities and sororities have dealt with over the years, there comes a point when you have a national organization that has college-affiliated chapters where they have guidelines on how those college-affiliated chapters operate, that when they know there have been hazing incidences that have led to injury or death, they suspend that organization, and yet very quickly, before all of the people who were involved in that hazing incident are no longer there, reinstate it with no further action. There comes a point when the national organization is responsible for what is happening in their name and should be held accountable. And that's the purpose of that section of the bill.
Okay. Thank you. Senator, is there any other discussion about the motion? Senator McDougal?
Mr. Chair, as I'm reading through this again, what do lines 118 to 121 do? Because does that mean that a institution of higher education would also be liable?
Mr. Chair.
Mr. Quagliata? Or
Mr. Chair, if they
Boyska?
have specific and credible knowledge that a group is planning to force someone to drink 40 shots of whiskey, they should be held liable.
Senator Boyska, I think it's about more than that, though. I mean,
And,
hazing can be lots of different things
on
besides alcohol
119.
involved. It can be physical, it can be psychological, it can be lots of things. So it's
On
not just
119, it goes beyond the higher institution to a member of the institution of
Governing
higher
board,
education's governing board.
to the Board of Visitors.
So a member of the Board of Visitors.
Yeah.
Mr. Chair, Senator McDougal is correct.
So, I mean, Senator Boyska, I'm just sort of detecting that this bill is going to need a lot of wordsmithing, a lot to get it anywhere near to where I think you'd probably get the votes, at least to get out of this subcommittee, or to get a recommendation of the subcommittee, I should say, because there's a lot of different people it pulls in a lot of different places. And no question there's a problem, and the civil system can deal with some of it, although I think from your constituents' point of view, it's been highly inadequate, which we appreciate. But I'm just detecting a lot of discomfort up here. Is there any further discussion about the
Mr. Chairman,
motion to strike that language?
Yeah, one other question I had as I was looking at it is, it says in line 97, the term hazing means the same as defined in 18256, but the definition in 18256 is it's unlawful to haze. at a school or institution? Is there-
Mr. Chair,
It's in somewhere else.
the definitions on, it's right above it on lines 87 to 94. For purposes of this section, hazing means to recklessly and intentionally endanger the health and safety of a student or students. And then the new language is so as to cause bodily injury, which will probably need to be struck
Right.
because of the striking of, but that's the definition.
That's
Subsection.
current law.
Right, that's the current law that is in 87.
I think we've had enough discussion on this section. So Senator Deeds moved, somebody seconded his motion to strike, I think Senator Norman seconded the motion to strike 95 through 123 from the bill. All those in,
I think that was Senator McDougal's motion.
oh, was it?
Okay.
Oh,
Okay. I'll take responsibility.
okay. Okay, Senator Norman moves, Senator, who's the second? Senator McDougal seconds. All those in favor of that motion to strike that language, say aye. Aye. Is anybody opposed to that? Senator McClellan? What about Morrissey? You have his proxy according to my blue slip. Got it. Okay.
No?
So that language is out of the recommendation. So now the bill remaining is lines, everything through line 92 with an amendment in concept that's coming for full committee.
Mr. Chair, since you struck that language on 13, 37 comes out. Is that?
Oh, right, that gives the authority, right. Okay, okay. So now we have a bill that cleans up 18.256 to create a safe harbor and make it clear that felony can be prosecuted.
That's correct, and preserving the mandamus for the attorney for the Commonwealth.
Right.
Mr. Chair, could I just ask another clarifying question?
Go for it.
Under the current law, is there or is there not an ability to charge someone with manslaughter or a Class 5? There already is.
Yeah.
Is that what you're telling me?
Yes.
So help me understand how we're improving the law here to increase the penalty, because I don't understand that.
Counsel?
Mr. Chair, what I would, to answer the patron's questions, what I would say is that the new language explicitly provides that a hazing charge can be brought with the other charges, so that it wouldn't be, it wouldn't be a potential defense to say, no, I just charge you with the hazing, not the involuntary manslaughter. This would allow the simultaneous, both charges to be brought against the person.
Senator Boyska, you want a final word?
The reason that we brought this bill forward is to make the penalty so great that schools and fraternities and other organizations would take this seriously and shut it down. I understand that what we're asking for is very punitive, but this has to stop. And we are the people who make the laws in Virginia, and we can say whether or not we think it's acceptable for us to continue to enable this. And I would ask you all to seriously consider strengthening the law, working with us to make sure that we're really serious about stopping children from dying when they're forced to drink 40 ounces of whiskey, not really understanding that they have an option otherwise.
Thank you, Senator Boyska. Senator McDougal?
Mr. Chairman, maybe I'm going to say this a little different than Charles did. Right now, if somebody brought a hazing statute, you could not, and they were convicted of that, you could not bring a manslaughter statute because you have been convicted of a specific statute.
Yes.
So under the law today, if that occurs, and one could argue if you brought the other statute, it's arguable that there was a specific statute, so you couldn't bring that higher statute. What this change would mean is it is clear to everybody that you could bring the higher statute, which is the felony of the Class 5 felony, and you could bring the Class 1 misdemeanor. So there are two separate possible criminal charges that could occur with the language here, where that's not possible today. I think, is that accurate?
That's accurate, Mr. Chair.
Mr. Chairman, I'm sorry, and Senator McDougal, I also would just note that it also clarifies that the safe harbor will apply to the felony charges, which I think will probably help bring aid to people who might be in distress, who otherwise might pass away or suffer a serious injury. And so I think that also would help the situation. So that, I think, as amended, sort of where it leaves the bill. Although I can detect you're not happy about it.
Obviously, you've chopped up my bill, but,
I'm going to say something, Mr.
Okay,
Chairman, it's
Senator
very
Norman.
controversial. This is a very complicated bill with a lot of moving parts and a lot of innovative approaches, and I respect that you are very skilled in some areas. You've got some extraordinary criminal lawyers who are sitting up here, and I am great empathy at the loss these people have experienced. There's nothing we can do to restore it. But that doesn't mean that we have to pass egregious laws that don't function well, and we don't pass laws based strictly on an emotional reaction. And this is some very, very perilous area of the law where we are trying to wordsmith it to improve it. And so it's not that we are hijacking your bill or rejecting. Your bill would never have passed in the current form it was presented. And these gentlemen have tried very hard to wordsmith it, to give you a product and to give this family a product of having something meaningful. It may not be what you want, but it is better than what it was when you presented it. And so we're not trying to be obstructionists. There are just certain legal criteria we have to meet.
I appreciate that, sir. And I appreciate your consideration and that you really worked on the bill. And I hope that we can move forward together to make a difference for people in the future.
Okay. Thank you, Senator. So I believe Senator Deeds had a motion he withdrew. You want to remake your motion to report and re-refer?
Report as amended, and I'd make a motion that we recommend reporting as amended and re-referring to finance.
Is there a second for that? Okay, all those in favor of reporting, re-referring the bill to, recommending reporting, re-referring the bill to finance, say aye. Aye. Anybody opposed?
And I made that motion with the understanding we may not have to go to finance. We may
Right.
figure that out by Monday.
Right.
Because we've taken out the new Class 5 felony. We've already got a Class 5 felony. We've just made it possible to reach that.
Right.
That's correct, Mr. Chair.
Right. Senator McClellan, is Morrissey and I? Okay,
Mr.
opposed?
Chairman, I'm voting no and Stanley is abstaining.
Okay, McDougal.
I want to see the final product that
Okay.
I'm voting on.
Okay. I appreciate your hard work, and I certainly didn't mean any
Okay.
disrespect to anybody.
Okay, thank you, Senator Boysko.
Thank
And
you.
I want to thank your constituents for coming down here today and providing your testimony, and we're going to give you deepest condolences for your loss. Thank you. Okay, members of the committee, we have two Evan bills. One of them, I believe, will be really fast, I think, or
I hope
should be
643
quick. And that one is Senate Bill 643. Can we do that one first, Senator Evan?
Yes, that'd be my preference.
Okay.
Because I have two bills that are very, they might seem
Senator-
similar, but they're very different.
Senator Evans, 643, is there a sub for that, or is it?
Yes, there is a substitute.
Okay, is there a motion on a substitute? So moved. Is there a second? Is there a second? Senator McClellan, how about we second? Okay, all those in favor of adopting the substitute, say aye. Anybody opposed? Okay, substitute is in front of us. Senator Evans, can you explain to us what
Yes.
this does?
I can. And I want to thank Mr. Van Cleve of the VCDL for helping me with the substitute, and Mr. Huggins for reviewing it as well from the state police.
Senator Evans, do you think we'll ever hear that ever again?
Let me say it louder.
I want
I
this
want
on
to
tape.
thank, I want to thank those gentlemen as well as some prosecutors, and I also want to thank some gun safety advocates, all together. Okay, so currently, the committee knows that the law makes it a Class 1 misdemeanor to remove the serial number from a firearm. And this came to me from some prosecutors who had situations where they found, where firearms were found at crime scenes without serial numbers. But this bill would make it a Class 6 felony to knowingly transfer any firearm whose serial number has been removed, altered, or destroyed. It also makes it a Class 1 misdemeanor to possess a firearm whose serial number has been removed, altered, or destroyed. In the substitute, we removed some words in the existing code that Mr. Van Cleve pointed out to me were a bit redundant or perhaps even unclear. The word defaces and other mark. We're going after the serial number or any other identification required by federal law. Federal law makes, as you know, possessing, transporting, or delivering a gun with an altered serial number a 5-year felony, but in Virginia law, that's not a crime, although North Carolina, I believe, has a similar law according to the NRA website. There's no good reason to remove a serial number from a firearm. It makes the device untraceable when found or connected to a crime. We know people should be punished more seriously for selling crime
Senator
guns.
Evan, can I short circuit this? Your bill
Sure.
basically makes it a felony to sell a gun with an altered serial number. It makes it a class 1 misdemeanor to possess one without a valid serial number. And it also makes it clear that if you actually do the removing, altering, et cetera, yourself, it's a class 1 misdemeanor. That's what it does, right?
That's correct.
Okay. First of all, I'm going to do this the Frank Ruff style. Is there anybody opposed to the bill? Okay. There's some lukewarm opposition I see in the back. You all want to come up and what was that hand signal?
Good morning, Mr. Chairman, DJ Spiker, NRA. We're close to neutral on this. Our concern is on line 19, knowingly is included in the new subsection B, and line 22, knowingly is not included in line 22. We're just concerned about including it in the new subsection, but not included knowingly in this other new subsection. Our concern is somebody's inadvertently swept in as a result of somebody overzealous. That's just our only concern.
Okay. Counsel, is that inadvertent?
I think it's probably inadvertent, probably be a friendly amendment to add in knowingly sell, give, or distribute.
Okay. Senator Evan, you okay with that amendment? Okay. I heard a motion and a second. All those in favor of the amendment say aye. Aye. Anybody opposed? No. Okay. Is there anybody in opposition in the Zoom room to the
Mr. Chairman, there are
bill
two.
as amended that everybody loves? Well, there's some people that want to speak in opposition, looks like.
Martina Lenz, would you please unmute and begin your testimony? Martina Lenz, would you please unmute and begin your testimony? Raman Fatihi, would you please unmute and begin your testimony?
I'd be happy to. I don't know if my colleague Steve Toscano from Fairfax is on. VPPFJ supports this bill. In fact, we drafted this bill.
Okay.
We think that
Mr. Fadahi, we appreciate it. We were looking for opposition just to see if anybody doesn't like this. So, okay. Anybody else in opposition?
Mr. Chairman, those are all the Zoom attendees.
Okay. Senator Evans, there's a motion by Senator Dees to recommend reporting referring to finance. I believe it was seconded by McClellan. Any other discussion? I don't hear any. All those in favor say aye. Anybody opposed? No. Okay. All the proxies are aye. Okay. All right. Senator Eben.
Thank you.
Committee, we ready to do ghost guns?
Yes.
6:17 p.m.?
I believe it's 6:43.
Okay. Committee's with you, Senator Eben, so try to keep us with you.
Or, I'm sorry, wait, it's 3:10. The other one was 6:43. This deals with a loophole.
Senator Eben, I believe you have a substitute, right?
Yes, there is a substitute. I apologize.
Okay, is there a motion to adopt substitute? Is there a second?
I don't know if,
The substitute just takes off the way it now.
okay, we can adopt.
Okay, is there a second to adopt? Okay, all those in favor say aye.
Aye.
Anybody opposed? Now we have a substitute. Senator Deeds, do you want to say something?
What I was going to say is, in an effort to streamline things, I think we all understand this bill. We had it last year and it died in conference. We
This
just
is
need to
different than
understand-
last year's bill.
We need to understand the differences.
Yeah. I believe I have some notes on the differences between last year's bill and this year's bill. This bill focuses on the component parts that are undetectable under usual security screening methods and does not include the case of a rifle or shotgun or the barrel of a firearm in that definition, like the 2021 definition. This bill makes it illegal to manufacture, import, transfer, or possess a plastic firearm or firearm with a component that's undetectable. The 2021 bill did the same, but to firearms after all major component parts are removed or undetectable. This bill makes it illegal to knowingly possess, transport, or receive an unfurnished frame. A part of the gun that is used when assembled makes it a functional firearm, unless you can receive that frame if you're a dealer, importer, manufacturer, or if the unfinished part has a federal serial number. That was not in the 2021 bill. The idea is that the dealers or importers or manufacturers have the capability to put a serial number on a frame, and some people, hobbyists who want to assemble a gun, we don't want to prevent them from their hobby, but we just want to make sure that the serial number is on the finished weapon as is required under the law on a complete gun. We just want it on the at least on the frame at minimum, and we don't want dealers to get swept up if they were to serialize a frame.
Okay, so, counsel, can you also explain the differences here?
Mr. Chair, in regards to the first part of the bill, dealing with plastic firearms, some of the language has been updated from last year's version. I can't really discern much of a substantive difference other than it seems to be more updated to current language. With regard to the component pieces, I think that Senator Evans accurately described what the difference is that last year there was some concern about the bill dealing with essentially people assembling their own firearm and then getting a serial number put on after assembling. This I think will allow that person to, after production, after they buy parts that don't have a number, get a number on it and not be in violation of the provisions of the bill.
Okay. How do you want to do this? In favor? Why don't we put a 5-minute clock on both sides? I just think it's more useful to take the opposition first. So how about we do that?
For those attendees in the Zoom room who would like to speak in opposition to the bill, would you please raise your hand right now?
How about we take the in-person ones first? And remember, we got people on the Zoom also.
Good morning, Mr. Chairman, DJ Spiker, NRA. Unfortunately, this area of code is incredibly complex. We dealt with this last year. To Council's point, Mr. Chair, the fact that this needed updating just 1 year later shows how complex this technology is. It's best left to the federal level. We have a number of concerns here. There's no grandfather clause for existing frames, receivers, et cetera. We feel these definitions are nebulous. Language such as an unfinished frame or receiver means any forging, casting, printing, extrusion, machine body, or similar article is completely nebulous. A block of aluminum, a frame, a piece of plastic could all do so. Anything reaching that, and once it reaches that point, that it becomes a stage of manufacture to be readily completed, assembled. These are lines 33 through 37. That language to us is very vague and generic. The concern is you have a homemade firearm, which does not require a serial number under federal law, so long as you choose not to transfer or sell. Those individuals will be required. There's no language here that grandfathers them in that's clear. Should somebody go to repair their homemade firearm, which they're not required to serialize, should they go to reassemble it, it is unclear under language 34 through 37 that they're in violation of the law. We have a lot of concerns with the vagueness of the statute, the lack of a grandfather clause. We have a number of concerns with this language specifically. And again, homemade manufacturers do not require a serial number. It's only when they go to sell it or transfer it, it's a violation of federal law if it's not serialized. But a hobbyist is not required to provide a firearm with a serial number. They have the ability to make it as a hobby that goes back as far as the Republic itself. So we have a lot of concerns with the vagueness of the language, the concerns that an overzealous prosecution with assemble could mean to reassemble. So somebody who's cleaning their firearm goes to put it back together. That is an assembly, and under that language there could be prosecuted as a result. And again, not to belabor the point, on line 38, having the word possess means grandfather clause does not exist. Thank you.
Okay, thank you. Next, Mr. Van Cleve.
Yeah, Philip Van Cleve, VCDL. I have a little handout here. One of the things that bothered us as well about this, and it goes back to grandfathering. In our Constitution, this would be considered a taking if suddenly something that's perfectly legal is made illegal and we can't even possess it anymore. The Constitution, and what I'm giving you there is Article 1, Section 11, and also comments by the Virginia Supreme Court basically saying that, yeah, personal property is covered by such a taking, And that if we have to pay somebody for taking their home, we also have to pay them for taking their car. And so, again, the fact that this is not grandfathered creates that issue. Thank you.
Hey, Counsel, can you just confirm that, you can stop the clock for a second, confirm that a taking only occurs when property becomes completely valueless, and that as long as the property is capable of being resold for money, it's probably not a taking under current law?
That's correct, Mr. Chair.
Okay, thank you. Okay, next.
Patricia Webb, VCDL, and I'm also a licensed gun dealer and FFL. As a manufacturer, I cannot put a serial number on a gun that somebody else has manufactured. It's against federal law. So the logistics of this law leave a lot to be desired in that respect as well.
Okay, thank you. Is there anybody, okay, let's go to the Zoom room.
Yeah.
John Calhoun, would you please unmute and begin your testimony? John Calhoun, would you please unmute and begin your testimony? Karen Peters, would you please unmute and begin your testimony?
Hi, my name is Karen Peters. I'm a resident of Richmond, Virginia, and I support this bill.
Ryan,
Okay, again, people in the Zoom, we're taking people who are opposed first.
Ryan Brutch, would you please unmute and begin your testimony?
Yes, I'm Ryan Brook of Roanoke, Virginia. Currently, there's no federal requirement to serialize homemade rifles or pistols, nor is there a procedure to obtain a serial number for those homemade firearms. And the majority of manufacturers will not serialize them due to liability, nor will FFLs purchase them. Thus, technically, it is a taking if the majority will not purchase them. Thus, all homemade firearms would become illegal under this bill as currently worded. I urge you to oppose it. Thank you.
Thank you, Mr. Brutch. Next.
Tanya Shart, would you please unmute and begin your testimony?
My apologies. I'm going to speak in support of the bill.
April Holmes, would you please unmute and begin your testimony?
I will be speaking in support of the bill.
Doug Peterson, would you please unmute and begin your testimony?
Doug Peterson, VCDL. I strongly oppose this bill. There's never been an issue with serial numbers on privately manufactured firearms before. I mean, why do we do this now?
Thank you, Mr. Peterson. Senator Evan, you have anybody in support who's
Yeah,
live?
I'd like you to hear from Ms. Shart, who's in the Zoom room, and I did have a comment to wrap up when you're done, when she's done.
Okay, it would also, I think, be helpful for the committee if the people in support could focus on the issues that were raised in opposition as well, so. Okay, so we're going to go to the Zoom room.
Tanya Shart, would you please unmute?
Hi there. Tanya Shart from Brady. Thank you so much for hearing us. We're very excited to be speaking in support of this bill. I just want to flag that there's been a lot of inconsistencies from the opposition. This bill does not target assembled guns at all. This is a very narrowly drafted bill that is targeting the parts and kits, which are unserialized, unregulated, and are currently being marketed that way to those who wish not to have background checks, who wish to avoid any encounters when they want to build a gun. So this is really narrowly tailored, just targeting those specific parts and kits to ensure that we prevent the continued proliferation of ghost guns. Ghost guns circumvent every existing gun law in place. And again, they are intended to do so. So plain and simple, this is not targeted at hobbyists. This is an industry that targets individuals who want to avoid background checks and mass produce untraceable firearms. It is important to proactively and aggressively prevent the continued proliferation of these weapons in Virginia. Again, this bill is very narrowly tailored. It doesn't target the assembled guns. It just targets the parts and kits that are being sold to teenagers, that are being sold to those who have been convicted of domestic abuse. Those are prohibited purchasers. All of these parties can go and buy these parts and kits, go home and build any number of guns that they want. It's past time to ensure that those parts and kits are not readily available to anybody and everyone. If somebody wants to build a gun, they can go buy a finished receiver that is serialized and complete the firearm at home. Thank you so much for your time.
Okay, thank you. Who's next?
Heather Foglio, would you please unmute and begin your testimony?
Hi, I'm Heather Folio. I am a resident in Fairfax. I'm also a volunteer for Moms Demand Action for Gun Sense in America, and I'm speaking on our behalf in Virginia. I will just say that ghost guns and downloadable guns and undetectable guns undermine gun safety laws, thwart law enforcement and threaten public safety. They're also the fastest growing gun safety issue in our country, and I urge you to strongly support this bill and make this a priority. Thank you.
Thank you for your testimony. Last speaker in support.
April Holmes, would you please unmute and begin your testimony?
Thank you. I just wanted to reiterate that I fully support this bill.
Thank you. Senator Evans, you want the last word? You want to address
Yeah.
some of the issues that were raised by the opposition?
Yeah, I do. First, we're going after the loophole of the parts that what would be illegal in a finished gun is just to make the parts be serialized. And we know it's easier to build a ghost gun than assemble an IKEA dresser. You can go to ghostguns.com and you can take a look at the AR-15 style build kit with files and ghost gun. Yeah, there's multiple serious weaponry. And we know that these weapons are particularly enticing for people who would otherwise not be able to pass a background check in Virginia, including domestic abusers, minors, or violent felons. We know these guns have been used in horrific mass shootings, including 2017, a man under prosecution for multiple cases killed 6 people and injured 10 in Rancho Tehama Reserve, California, with 2 assault-style rifles he assembled using parts online. There are many of them, but I'll just mention one other. In 2019, a 16-year-old used a ghost gun to kill 2 students and injure 3 others at Saugus High School in California, too young to legally purchase a gun, but he was able to get these parts from the internet. We know that the measures in this bill support legitimate gun sellers who can lose business to those selling guns and parts and kits which are marketed as unregulated and untraceable. There's just no good reason for them. If it was the committee's pleasure, I like the bill as it is, but it was pointed out to me that section B of the substitute might be the more controversial piece. But I mean, I support the bill as it is, but the committee might see otherwise. I don't know.
Thank you, Mr. Chairman. Mr. Senator Evans, can you keep saying that? I'm going to get over that. Senator Evans, what's your response to the fact that we're criminalizing things that people already own?
Well, I think if you got rid of section B, it would go after the sale and transfer and purchase of these items. But people can take these weapons to a gunsmith and have them serialized, is my understanding. But if you were to delete section B, it would get away from being able to sell them, transfer them, or purchase them in Virginia, the unfinished frame or receiver, unless the person is an importer, manufacturer, dealer who could serialize it.
Okay, Senator Evans, what's your response to the concern that this could create issues for unassembled legal guns, I think is what the NRA said?
It's my understanding under federal law that an assembled gun is supposed to have a serial number. So put the serial number on the frame of the receiver, or if you're purchasing new ones, get them with the serial number already on them. They're available.
Okay. Right. Are there any other questions from the committee?
Mr. Chairman,
Senator Edwards.
When you refer to B, there are 2 Bs.
In the on page 2,
lines 38 through 41.
Yeah.
Senator Edwards, does that help? Senator Evans, I think you got somebody trying to help you behind you.
I'm sorry.
Well, I believe Charles.
Okay, Charles, did you have something you wanted?
This was just a technical amendment on line 27, the catch line, and unserialized firearms needs to be stricken. That's just a technical amendment, but I believe what Senator Evans was trying to, and I'm not sure, but was trying to say it may resolve some of the issues to strike lines 38 and 41.
What would that do? Yeah, Charles, what would that do?
Mr. Chair, essentially that would prohibit the selling, offering for sale, and the transfer or purchase of these unfurnished frames or receivers. So after July 1, you can no longer purchase these kits. But anyone who currently possesses a kit, they're still allowed to possess them, as well as any, can still possess any unserialized frame or receiver. It's not taking away the possession, just the subsequent transfer after July 1.
Got it.
The goal is,
Ms. Haas, hold on. You gotta come through the chair.
excuse me.
Ms. Haas.
My name's Lori Haas. I'm
Very
with the
briefly.
Coalition to Stop Gun Violence, Mr. Chair, and members of the committee. The goal is to require sellers and manufacturers of unfinished frames and receivers to put a serial number on them. That's it. It doesn't attack and doesn't capture currently owned firearms that have been assembled and that do not have a serial number on them right now. Line 27, an unserialized firearms penalty is supposed to not be there. It is a prohibition on unfinished frames and receivers that don't have a serial number. And again, it's going forward. It is not going backwards and capturing anybody who currently owns a firearm that they purchased the pieces and parts for it and assembled at home and currently own it.
Okay,
So the problem with assembling or reassembling or cleaning is non-existent. This is going forward. It would require manufacturers and sellers to put a serial number on any unfinished frame or receiver. That's all it does.
Senator Deeds?
And so, Charles, you're saying that if we take out the language on lines 38 through 41, it will only be prospective. It will be people that will already own these weapons will be able to keep those weapons.
Correct. That I believe would be the intent behind it, and would allow, by eliminating the possession prohibition, you're allowing people to possess.
I will move that
Okay.
amendment.
Senator Deeds moves this, I think he meant to make two motions. One is to do the technical amendment to strike in unserialized firearms from line 27 and strike lines 38 through 41. Is there a second to that motion? Senator? It's been seconded. Any discussion on that? All those in favor of the motion say aye. Aye. What's about Morrissey? Is he an aye, Jen? Okay, all those opposed? Okay, nobody's opposed.
You want to strike lines 38 to 41?
We already did that, Mr. Senator Edwards.
Okay, all right.
All right, so now, as amended, is there a motion on the bill?
Move report.
Is it moved to recommend reporting the bill and re-referring it to finance, seconded by Senator Deeds? All those in favor of that motion, say aye. Aye. Anybody opposed? I'm sure you guys are opposed over there, right? Norman, McDougal, no?
Taking the vote on I'm opposed and Stanley's abstaining.
Yep, okay. McDougal, okay. McDougal's a no, Norman's a no, Stanley is abstain. Okay. With that, we're done. The committee will rise and see everybody on Friday, 30 minutes after we get off the floor.
Thank you, members of the committee.
Friday.